Mr. Denver.
Much obliged. Lords and ladies, I'd like to begin by just outlining the background to these proceedings. There was a trial of this matter in Trinidad and Tobago on the 6th of July 2017, which lasted for 10 days. There were 4 witnesses on behalf of the appellant, Methanex Trinidad, and 2 on behalf of the respondent. There was extensive cross-examination. Regrettably, there were no transcripts, but the evidence has been analyzed, and there are submissions from both sides and the respondent in this regard in relation to the matters before the Tax Appeal Board. There are just 2 witnesses whose names will feature in these proceedings. One is Ina Chow, who is a Senior Treasury Manager at Methanex Canada, and Mr. Bernal Arundel, who is being presented to this board as an expert witness. Not being a lawyer nor an accountant, having no qualifications in either field. But we'll come back to that later on. Now, the whole process of these dividend payments, the 4 dividend payments, can be traced back to Ms. Ina Chow. And Ms. Ina Chow gave an affidavit in February 2017. But 3 days before the trial, on the 6th of July, an application was made to admit her affidavit as evidence, although on the basis that she could not be found. And we comment on that in our submissions. If I can take the lordships and ladies to the comment which is made upon that in our submissions before the Tax Appeal Board, and as we found in the record at page 119, electronic bundle.
119.
119, I'm sorry, 119.
Yes.
119. Paragraph 34 says, Ms. Chow, in very clear language used in the email, is anticipated that the appellant would rely on evidence from one or more of Ina Chow, Joan Furlong, Lisa Pariak, or Shervin Valley. In fact, an affidavit of Ina Chow was filed by the appellant on the 6th of February 2017. No evidence was filed from either Joan Furlong, Lisa Pariak, or Shervin Valley, all of whom were involved in 2007 in the circumstances surrounding this appeal, and 2 of them were actually involved in the audit. On 3rd of July 2017, a mere 3 days before the commencement of the hearing of the appeal, the appellant filed an application for an order or direction to this Honorable Court that it be permitted to rely on the content of Ms. Chow's affidavit. The appellant informed this Honorable Court that it could not locate Ms. Chow in order to make arrangements to have her present for cross-examination at the hearing of the appeal. Interestingly, there appeared to be no difficulty in locating and securing Ms. Chow's cooperation in giving a statement and signing the affidavit some 5 months before. Now, having said that, if I can take your lordships in relation to what the Tax Appeal Board said about Ms. Chow's absence. And that is to be found at page 279 of the electronic bundle. Paragraph 104. And I quote, In addition, we are of the view that it is unfortunate that Enid Chow was not available for cross-examination, as her evidence, especially as to the facts and circumstances leading to her much referenced email, was ripe for cross-examination in which the veracity of the statements in her affidavit evidence could have been placed under further scrutiny and therefore contributed to a more thorough evaluation of this critical facet of the evidence. Now, all of that was said in the context of the whole process of dividend payment, or the requests for dividend payments to be made from Trinidad to head office in Vancouver. That was how the whole process started. And that is what I like to draw this court's attention to as to what the findings of fact.
Well, just very briefly, what was it that she said in her affidavit that contradicted that?
She said in her affidavit, if I can take you to the affidavit, page 1876. In her affidavit at page 1876, and I'm referring here to paragraph 7, she talked in the preceding paragraphs about her email, the relevant email is the 20th of July 2007. It is referred to paragraph 6. At paragraph 7, she says, if I can take you to the terms of the relevant email.
Well, just looking at paragraph 7. So what she seemed to be saying there was that it wasn't a mandatory instruction.
Yes.
Right.
Yes, it was. And what we say in relation to that, she attempted to resile from her instruction. Because one has in the evidence before the court the agreed statement of facts at paragraph 12.
Sorry, can you give me the page number again?
Sorry, the page number for the affidavit is...
No, the statement of facts that you're going back to.
Statement of facts, very well. 2371. It starts at 2371, and the relevant paragraph would be paragraph 12. Paragraph 12, page 2371 was the original start, and that's at 2373. This is on the agreed statement of facts. And these are the events leading into the commencement of the dividend payments, which are an issue in 2007. The total sum being $85.4 million, which emerged in four tranches over a period of 3 months: July, August, September, October, for 4 months from Trinidad to Vancouver, Canada, without touching Barbados. And what was said in that email, 20th of July 2007, from Ms. Chow, she said, and I quote, based on the Q3 2007 cash repatriation forecast, we will require funding from Methanex Trinidad in the form of dividend payments as follows. 10th August 2007, $25.4 million. September 4, 2007, $20 million. Please note these dates on the calendar and ensure that dividend resolutions are ready in time. Please note that the global MIK calendar will confirm the timing of NELT or other meetings where Jorge or Randy Milner may be unavailable. So that was, as far as the Tax Appeal Board was concerned, a direct instruction. whereas Ms. Chow sought to suggest at paragraph 7 of her affidavit, she did not determine or direct what dividends the appellant ought to declare. But she wasn't there for cross-examination. So that is the background to the whole process. And it's based on the cross-examination of all the witnesses that these findings were arrived at by the Tax Appeal Board, which the Court of Appeal upheld. If I may take your lordships and your ladyships to the electronic bundle in that regard, at page 858, paragraph 59 of the Court of Appeal judgment. And if I may quote, and this is the Court of Appeal upholding the Tax Appeal Board, I quote, "There is no basis on a review of its reasoning to conclude that the TAB was plainly wrong in its determination that, 1, the transactions which purported to be a payment of dividends by Methanex Trinidad to its parent Methanex Barbados, which would attract withholding tax at the rate of 0%, were actually payments of dividends to Methanex Canada at its request and direction. 2, they were artificially routed through Methanex Barbados in accordance with a preconceived plan to avoid the 5% withholding tax payable thereon if those payments had been transmitted directly from Methanex Trinidad to Methanex Canada. The evidence is that at least 3 of those payments were requested by Methanex Canada in advance of the declaration of the dividends in the exact amounts requested before any discretion was required to be exercised by the boards of Methanex Trinidad or Barbados to declare dividends in those amounts. And Methanex Canada is not the direct parent company of Methanex Trinidad, yet Methanex Canada requested those dividend payments from Methanex Trinidad. This is more than sufficient to support the TAB's view, that no independent discretion is being exercised by the boards of Methanex Trinidad or Methanex Barbados in declaring dividends which had been predetermined in form, amount, and time of payment by Methanex Canada. In relation to these payments, the TAB was therefore entitled to find that the declaration of solvency by the directors of both Methanex Trinidad and Methanex Barbados prior to their declaration of dividends did not establish conclusively that those declarations were the product of their own independent discretion. 3, the dividends paid to Methanex Barbados were to an account in Vancouver, Canada, under the sole control of Methanex Canada. 4, after the dividends were paid by Methanex Trinidad to Methanex Barbados, dividends in those exact amounts were also declared by Methanex Barbados and transmitted to Methanex Cayman. 5, the dividends paid by Methanex Barbados to Methanex Cayman were transmitted to an account in Vancouver, Canada, under the control of Methanex Canada. 6, the rapidity with which that request was given effect and its facilitation by Methanex Barbados were also matters that the TAB was entitled to take into account in its assessment of whether, in fact, the payments of dividends to Methanex Barbados were actually payments of dividends from Methanex Trinidad, intended from inception to actually be for the benefit of Methanex Canada. And goes on at paragraph 19. In those circumstances, the transactions, insofar as they purport to be simply payments.
Where are you reading now?
Sorry, I'm just going, paragraph 19?
90 or 6, we're at 61. Yeah.
Yes.
Sorry.
Sorry, paragraph 61 of
So we're in the judgment of the Court of Appeal.
judgment of the paragraph 64, EB 8.
Oh, 64.
64.
Sorry, paragraph 64, I'm sorry.
Right.
Paragraph 64 of the judgment of the Tax Appeal of the Court of Appeal, where it concluded, in those circumstances, the transactions, insofar as they purported to be simply payments to Methanex Barbados, attracting 0% withholding tax, could legitimately be characterized as artificial and fictitious. The PAB could not be faulted for doing so. So those are some of the main findings of fact, which my friend did not refer to, which in our respectful submission.
Well, he did refer to them, but what I seem to gather is that the case before the tax board was rather different from the case being run now. It was, despite the wording of that instruction, this was not really an instruction. It was all in the discretion of the board of Trinidad and Tobago Company, whether they would pay this. That was then found not to be the case, and it seems that the Court of Appeal may have thought, well, that means then, given that they've lost on the factual case they were mounting, that they are artificial, and Section 67 is triggered, whereas the case that you have to meet now is, even accepting those findings, it's still not artificial. But before the tax board, did they also argue, Methanex, even if you find against us as to what Ms. Chow said, it still doesn't, it's still not properly described as artificial for this purpose? Or at that stage, was it turning on this dispute about whether whether there was discretion or whether it was an instruction or not?
Well, clearly, in my respectful submission, what the tax appeal board found was that there was an instruction, there was no discretion.
Yeah.
And it said so very clearly in its judgment.
Yeah.
And my friend has sought to raise in his submissions that there is no evidence of the absence of a discretion residing in the directors of the boards. But that is totally inaccurate. And if I can point you to that, where that suggestion was made in their submissions. It would be in the paragraph 23 in our submissions, which would be in the statutory electronic bundle. Paragraph 283.
283.
Yes.
So what this is,
It's page 2431.
Yes,
243.
paragraph 23, page 2431.
Page 2431.
Thank you.
That's good. At paragraph 2431, what we say is that the appellant's case with selective extraction of phrases in relation to the findings of the tax appeal board, which were upheld by the Court of Appeal. And a misleading narrative could have developed when considered the totality of the facts. And in its case, what the appellant said very clearly was, and I quote, "In particular, there was no evidence in this case that any board abdicated its role with regard to the declaration of the dividends. That has not been found to have occurred either by the Tax Appeal Board or the Court of Appeal. Unsurprisingly, so as there was no evidence upon which a reasonable tribunal properly instructed as to law could have come to such a conclusion." What we say in relation to that submission was that is totally inaccurate, false, because there was a specific finding by the Tax Appeal Board.
but that's not about discretion, is it? That's about whether the board made a proper assessment of whether there was sufficient liquidity to make the declaration of to declare a dividend, isn't it? Isn't that what they're talking about when they say didn't abdicate their role in relation to the declaration of dividends? There's a legal requirement.
Yes, but in addition, the suggestion, in my respect for submission, that they didn't exercise any independent, there's no finding about.
That's not what 93 is about, is it? I understand I understand your point about the finding.
Yes.
But the case that, well, doesn't matter.
What we say is that the clear finding of the Tax Appeal Board was that the directors of both Barbados and Cayman exercised no independent discretion or judgment, but were
That's
following.
accepted now.
Yeah.
Yes.
It's accepted now that, yes, they did. There's no debate about whether there was adequate solvency. There was, and they made the necessary declaration, and that declaration was correct.
Yes.
The question for us is whether the fact that there's a finding that once they'd done that, they absolutely were always going to comply with the instruction from the high-ups to send the money as and when requested, whether that means that the dividend is artificial or not. Because they accept now that that was the situation. Whatever Ms. Chow may have tried to row back from the wording of her email, they realise that they can't undermine that. The question is, what does that mean for the application of Section 67?
That's right. Yes, but what it means for the application of Section 67, two things. One, we say that it was artificial because it was not a payment. It was presented as if it were a payment of dividend by Methanex Trinidad to Methanex Barbados, which it was not.
Well, when you say it wasn't, it strictly in legal terms, there was a declaration by each of those boards, followed by a payment of a dividend by each of those boards as a matter of fact and law.
Yes.
So what's artificial?
It was never received by Methanex Barbados. It was never under the control.
Well, it was received into their bank account.
Into their bank account in Vancouver.
But where is the requirement that it be received into a bank account in Barbados?
The requirement is not a requirement. What I'm saying, the totality of the transaction, any innocent bystander will say, a payment of dividend by Methanex Trinidad to Methanex Barbados would not go into a bank account in Vancouver at the same branch under the control of the parent company. Methanex Barbados had nothing in Barbados.
So just exploring that, had this payment been made into a bank account in Barbados and then immediately paid out, just as it was, to the bank account for the Cayman entity, and then immediately or soon afterwards paid out to the Canada company, would your argument be the same or would it be different?
If the Methanex Barbados bank account was under the control of the board of Methanex Barbados, and if signatories in the Methanex Barbados account in Barbados had done payment of dividend, the position may be different. But that is not what happened in reality.
I mean, is not really the point you're focusing on control of the bank account rather than where the bank account was?
But all of those things were there.
Because, I mean, as I understand it, the bank account of the Trinidad company was in New York.
Yes, it had bank account in New York. Yes.
Well, I don't know if it had a local bank account as well.
It would have had, because
But anyway,
steps taken.
the short point there is that, so far as we know, I mean, it's not suggested that the Trinidad company's account in New York was not under the control of the Trinidad company.
That's not suggesting, no.
No. So it's not the geographical location of the account that matters for your purposes, is it?
In my
It's the control over it.
One element, location, control,
But why does location matter?
because the whole concept of the CARICOM, of the Revised Treaty of Chaguaramas, is a question of circulation of capital within the region. That is one
We
of
have no idea, sitting here, how many companies in Trinidad and Tobago or in Barbados actually have their main bank account outside those territories. It may be that everybody does for whatever reasons. I mean, is there anything that you can point to show us that that's a kind of an unusual occurrence?
I wouldn't say it's an unusual. What I'm saying, the totality of the circumstance. It was presented as if it were a payment to Methanex Barbados.
But when you say presented, well, I don't know what you mean by that, because there was a declaration and there was a payment.
There was a payment.
So what do you mean by presented?
Well, it was presented. He said, monies are being paid from Trinidad to Barbados.
Yes. And they were?
They were paid not to Barbados, they were paid to Canada.
Well, they were paid into an account in Canada, but they were paid to...
And the monies were not under the control of anybody from Methanex Barbados.
Well, I think that's the point perhaps which we ought to just focus on for a moment, because what we know is from the findings made by the tax board that there was a Treasury Services Agreement between the holding company, the Canadian company, which had the Treasury function, and these various subsidiaries, under which the Treasury Department in Vancouver, I assume, performed certain services. That's, I think, the language of the decision, which sound as if they could be Treasury services, putting the money out at the best rate of interest, overnight deposits, whatever it happens to be. And the signatories on the accounts were officials within the Treasury Department. But there's no suggestion in the evidence that the officials of the Treasury Department could, on behalf of the Canadian holding company, help themselves to the money credited to the accounts of, say, the Barbados company and use it just as they wished. It would have to be within the authority conferred on the signatories. So they would be bound by whatever their mandate was.
Yes, but their mandate would have been acting in the capacity of being acting on behalf of Methanex Canada.
Well, I mean, I don't think that can be right, because if you're a signatory of a bank account in the name of Company A, you're acting on behalf of Company A, not on behalf of your employer.
But in my respect, yes.
Sorry.
In my respect, what was standing out for the Tax Appeal Board and the Court of Appeal is that the monies were under the control and direction of Methanex Canada.
Well, that's what I'm just trying to explore with you, what we mean by being under the control and direction of Methanex Canada. I mean, I understand it in terms of performing services under the Treasury Agreement. That's what is referred to by the Tax Appeal Board. But the Tax Appeal Board does not find, and I don't think there's any evidence to suggest, that the funds in those accounts could be used entirely at the discretion of Canada. And if they were transferred, there would presumably be a debt due to the Barbados company until a dividend was declared. I mean, when you talk about an account being under the control of Canada, that's actually somewhat ambiguous, because it may mean that Canadian Treasury officials are signatories, which they are, or it can mean, well, we can do with it as we wish. But that latter meaning, there would really have to be some evidence to support that, because it's really treating Barbados, I mean, it's sort of allowing the holding company just to use Barbados as if it was itself.
In our respect, Mr. Minister, that's what the Tax Appeal Board was clearly suggesting.
They don't spell it out like that. They just use this phrase, under the control of.
Perhaps I can actually take
By all means.
to the evidence,
Well,
Tax Appeal Board.
what
Yes.
they say, yes.
Okay. The evidence would really start, the analysis of the evidence by the Tax Appeal Board would have started at electronic bundle 280.
280. Yes.
And that's really paragraph 105. what they're doing here, if I can go back to 279, going over to 280. Starting at paragraph 105 of the Tax Appeal Board judgment.
Is this from a quote from the submissions, or is it from their findings?
It's from the findings of the Tax Appeal Board.
Is that right?
Yes.
101 is the appellant doesn't accept.
Sorry, 279, 280.
279.
Perhaps the nearest to it, paragraph 108
108.
seems to address the arrangements for these accounts.
Yes, I was sort of leading into that, Millard.
I'm sorry.
Yes, no problem. At 105, they started to, this is the judgment of the Tax Appeal Board.
Okay.
At 105, at page 280, electronic bundle says the relevant documentary trail detailing the movement of funds from Trinidad to its parent company, Barbados, were realized within 2 business days, and goes on to outline the details at 105, and then amounts which were remitted, 106, along the corporate chain, etc., were the equivalent amounts in any commingling with the existing funds of Methanex Trinidad Holdings, which is Methanex Barbados, were momentary, as the equivalent amounts were transmitted within a relatively swift time from the initial receipt by the receiving entity, pending the execution of the necessary paperwork to facilitate transmission by way of the necessary resolutions and banking instructions. At 107, it says, with respect to Methanex International Holdings, that's Methanex Cayman, and the dividends it received from Methanex Trinidad Holdings, which is Methanex Barbados, during the year 2007, it was acknowledged in the testimony of David Merlin Lloyd Roberts that it received $85.4 million from the entity, and this was one of 4 subsidiaries from which it received dividends in the year in total, etc. Now 108, which is the point Lordship Richards, I believe, was raising. 108, so on the question of the location of Methanex Trinidad Holdings Limited's bank account being in Canada, that's Methanex Barbados. The appellant, through the evidence of Dean Richardson, maintained that the location of the bank account was consistent with the Treasury agreements in place between the Methanex Corporation and its holding companies, which the Treasury Department of the group would perform certain services on behalf of particular subsidiaries. In the cross-examination of Dean Richardson, it appeared that the signing authority of the holding company's bank accounts was also within the ambit of the Treasury Services Agreement and entrusted with the persons within Methanex Corporation in Canada, as opposed to the persons within the management structure of the respective holding companies. Nor were the bank accounts held in the jurisdictions in which the respective holding companies were resident. Similar responses were also listed from the testimony of David Merlin Lloyd Roberts during his cross-examination on a similar line of questioning regarding the location and signatories of the bank account of Methanex International Holdings Limited, that's Methanex Canada. And then goes on at 109 to say, a critical observation was that the transmission of funds through a transmission of dividends spanning 4 jurisdictions, Trinidad and Tobago to Barbados, the Cayman Islands to Canada. In contrast, the banking trail actually spanned 2 jurisdictions, Trinidad and Tobago to Canada, the funds being held transitionally in an administrative capacity under the control of the Treasury Department of the ultimate parent company, in accounts with both subsidiaries maintained in Vancouver, Canada, in accordance with the Treasury Services Agreement before legal titles of the funds were vested in the ultimate parent. So that was before legal titles to the funds were vested in the ultimate parent. So those are the findings of the Tax Appeal Board, in my respectful submission.
Yes, I mean, I don't take the board to be rejecting the evidence of Dean Richardson and Mr. Lloyd Roberts, which is recited in 108. That doesn't seem to me that that's rejected. And that seems to indicate what the Treasury Department, admittedly in very general terms, but indicates what the Treasury Department was doing. performing certain services on behalf of particular subsidiaries. With the fund, with the signatories,
Yes.
it is true,
Yes.
being officials in the Treasury Department, but doing the best one can here, their authority is bound by the terms of the agreements with the Treasury Department.
Yes. But it would be my respectful submission that at the end of the road, the board was of the view that these monies really vested in the ultimate parent, Methanex Canada.
But when had this, do we know roughly when the Treasury agreement was entered into?
It was never disclosed. It was extracted in cross-examination, it was never
Right.
disclosed.
Yeah, paragraph 111 explains that the agreements were not in evidence.
Right.
Sorry,
110,
110.
not adduced in evidence.
Unfortunately, the respondent raised the issue very late.
Oh, I see. So that we don't even know when the Treasury... The point of my question is that the Court of Appeal were very clear to say that they were not, by their judgment, impugning the propriety, if I can use the general term, of dividend payments generally. But what I wanted to know was whether there have been other dividend payments that have gone up the chain, other than these four which the revenue has challenged, which also went through the Vancouver bank account, controlled by the officers pursuant to that agreement? Or is it your case that this bank account was set up and this control only related to these four dividend payments?
Yes, as far as we know, that's it's limited to that. We have no other evidence about any other.
What, the account was set up specifically for the purposes,
no.
and the Treasury agreement put in place specifically for the purposes of these four payments?
That is never part of the
no.
evidence, no. But we don't have any evidence of any other type of dividend payment, apart from these four, going into that particular.
Really?
That was not an issue, because we're dealing here just with the income year 2007. We don't know what happened before or after.
Well, that's surprising, because the Court of Appeal specifically says that they're not challenging other dividend payments that have been made, just these four, because of what they regard as particular circumstances. And what I'm trying to ascertain is whether this bank account business was specific to these, or whether there are other dividends that have been paid over the years by Caribbean subsidiaries through this method.
There's no evidence of that. That was never an issue of the hearing.
Well, as I understand it, there's no evidence of any other bank account.
No.
So the assumption must be that the account with the Royal Bank of Canada in Vancouver is the bank account of Barbados, and perhaps more significantly, is the bank account of the Cayman.
Yeah.
Yes. And both were the same branch and
Yes,
1025.
but those were their bank accounts.
Those were
There's no suggestion, I think, that I've seen that those bank accounts were set up specifically for the purpose of these dividends.
No, there's no suggestion. No.
And you're not able to tell us whether any other dividends paid by the Trinidad company have been challenged on by the tax authorities in a similar way to these dividends?
We're in no position to say that.
No. Okay.
Whilst I'm on the judgment of the Tax Appeal Board, if I can take your lordships and the ladies to the page 282 to 283. It says, I'm very brief here before time expires. So again, Paragraph 114. Against this background of our analysis of key factual issues, we've taken into account.
I mean, we have read this carefully, and these are key findings. I think it would help us if you could tell us why these findings support the conclusion of artificiality.
Yes. But we say that they support the conclusion of artificiality because if one is guided by Lord Diplock's judgment in the Aramco case, what that judgment clearly suggests, one looks at the context and the terms of the transaction, and in order to establish whether a transaction is artificial, one has to consider terms of transaction and the circumstances in which it was made and carried out. And we say so in the electronic bundle at EB 2769 in the Aramco case. And we will quote his judgment on artificiality. And we say, when one takes into account Lord Walker's statement in the cigarette company case, or whether a transaction is artificial, is it abnormal? Would an innocent bystander say, in the real world, this would not happen? What we say in relation to this transaction, or these transactions, taken in their totality, is that they were entered into for the purpose of benefiting from the zero rate of tax on the payments from Trinidad to Barbados. If the monies had been paid directly from Trinidad to Canada, 5% withholding tax would have been charged.
But I mean, that, perhaps we get to the point here. But how could the Trinidad company pay the dividends directly to the Canadian company?
No, they couldn't pay them directly, no.
They had to go through the chain.
Yes. But if they went through the chain in a fashion which was consistent with the recipient in Barbados having a genuine operation in terms of a bank account and transmitting the monies to Canada as another dividend or transmitting the monies to Cayman, then that would have been a genuine transaction.
So what would have made it genuine? Just can you go through that? So
It becomes, in our respect, it would be genuine if Trinidad had paid to Barbados.
If what? Trinidad paid
to
Barbados.
And it went into an account in Barbados, and the directors sat down on a decision and made a decision to pay a dividend to the parent, which would be Methanex Cayman, and it had gone from Methanex Cayman to Vancouver. And what we've set out in our submissions in relation to that process, if I can take ladies and millards to page 2438 in the electronic bundle. Paragraph 51 in our submissions. What we say at paragraph 51, it's important to emphasize that in the context of a claim for relief under the DTA, that's a double tax treaty, the use of a conduit company is regarded as a quintessence of artificiality. This is perhaps best demonstrated by the 1992 OECD commentaries on Article 1 of the Model Tax Treaty, which discussed the improper use of the convention. The only example given is where A person uses artificial legal constructions, such as where a person acted through a legal entity created in a state essentially to obtain treaty benefits which would not be available directly to such a person. And we rely on the OECD commentaries.
But are
There's no, sorry.
Are they commentaries on an article in the CARICOM treaty? Is there an article to that effect in the treaty that we're looking at?
There's no specific article in the treaty, no.
Right, so that's an OECD commentary on an article in a model treaty,
Yes.
but what I understand is that the treaty we're looking at is not actually that model treaty.
It's not a model treaty, no.
But this is the argument that the Court of Appeal rejected.
Yes,
They did not accept this argument.
yes. What,
They said that they did not accept your submission that the Barbados company was a conduit company. They said it had a genuine independent existence, albeit that it had been established primarily for tax purposes. So,
well,
I understood you to be supporting the decision of the Court of Appeal.
well, not in every respect. The
So
decision,
you say they were wrong to, but that, what should they have held then? That there was no legitimate, no non-tax purpose for the interposition of the Barbados company?
well, the Barbados company was interposed there for the purpose of facilitating the treaty being availed of by the
Yes, well, they accept that that was
Yes.
the significant part, but the evidence before the appeal board, which the appeal board accepted, was that there were other purposes for the existence of the Barbados company.
But in relation to these dividends, the Barbados company is acting in accordance with a predetermined plan.
Well, yes, but that doesn't make it a conduit company. I mean, your case, I think, is that for the purposes of these dividends, it was being used as a conduit. Is that, I mean, I don't want to split hairs, but
Yes.
that's really the way you're putting it.
That's very, but
Yes.
much about it.
Okay, I understand.
But was there actually a business? Did Methanex have a business in Barbados?
Well, Methanex Barbados is a holding company
Yeah,
with no
there's no business.
evidence of a business, no.
But there is a business in Trinidad and Tobago.
Yes, Trinidad is the business. There's an actual plant and major contributor to the overall Methanex production of methanol, which I believe is about 20% of it's the world's largest producer and marketer of methanol, we're told. And I think the Trinidad plant is about 19 or 20% contribution. That was the position at that point in time, at least. Finally, I'd like to draw the Court's attention to the page 283. Paragraph 114C of the judgment of the Tax Appeal Board. And I quote, "There was a predetermined plan conceived in advance for the transmission of funds from the appellant to its parent, ultimate parent. Despite the passage of the dividends through remittances by the honored relay up the corporate chain to recipient parents, the amounts which the ultimate parent received were in equivalent amounts to what was actually intended. Whilst the directors of both the Barbados and Cayman Islands holding companies may exercise independent thought in other matters of strategic decision-making relating to those entities, as it related to the remittances in this instance, they exercised no independent discretion or judgment, but were following the procedure in what was a preconceived plan to transmit dividends of defined amounts up the corporate chain in a manner which yielded a tax-free result. The role of the holding companies in the particular transaction was that of conduit companies or a vehicle used as a virtual funnel to achieve a tax-free result in which dividends were remitted along the corporate path, beginning with the appellant and ending towards the ultimate parent in Canada. This process was also consistent with the cash repatriation forecast prepared by the Methanex Corporation, as suggested by Enid Chow in her capacity as an officer within the Treasury Department of Methanex Corporation, in her email of the 20th of July 2017, to personnel from the appellant's accounting department. Such communication being made in advance of what actually occurred with the projected payments in the amounts of $25.4 million and $20 million US being received by Methanex Trinidad Holdings, which would be Methanex Barbados, on 10th August and 4th September 2007. These payments were congruent with both the quantum and target dates specified in the Chow email, etc. So, in our respective submission, those are the findings of fact which led to the invocation of Section 67.
Can you just tell me, please, what the evidence before the appeal board was about what happened in the Cayman Company?
Yes. The evidence before. What happened in the Cayman, all we have on the record would be the cross-examination. We don't have the cross-examination. What we have is the affidavit, if I can refer your lordship to the affidavit of one of their witnesses. Yeah, it's the affidavit of David Merlin Lloyd Roberts, 6th of February 2017.
Page number?
At page 1759, 1759, going over to 1760. And what he says at paragraph 7,
Paragraph 7, yes.
yes, he's managing director of Methanol International Holdings, that's Methanex Cayman. He says, during the year 2007, MIHL's total income was $274,684,957 US, of which $826,000 represented income from cash investments and interest income, and $273 million represented dividends received from 4 of MIHL's subsidiaries. Of the $273 million odd, that was received as dividends in that year. $163 million was received from Methanex Chile Limited, and 85.4 was received from Methanex Trinidad Holdings, which would be Methanex Barbados. Mm-hmm. No. So that is what
He gave evidence, didn't he? He was cross-examined,
yes.
but not in relation to those points.
I mean, we don't. I mean, I would observe that affidavit evidence doesn't support what the tribunal says in subparagraphs C and D here, so far as the Cayman Company is concerned. He was cross-examined, but I don't know. We don't know what evidence he gave.
No. That was all that's on the record. So what I respectfully submit to this honorable board is that the transaction was not only artificial, but is also fictitious. And we say the element of fictitiousness emerges from the fact that as far as was found by the court, nothing was payment to Methanex Barbados did not actually occur. It was a sham. There was no payment to Methanex Barbados because of the factors which I've repeatedly referred this honorable board.
That's the bank account being in Canada and the treasury function.
Treasury function, and the tax appeal board concluding that the ultimate parent is the beneficial owner of the money. If I can now move on to deal with the tax appeal, the treaty. Going on to the treaty. The treaty point.
Yes.
Yes, please. Much obliged. That was section 67. The treaty point we have set out in considerable detail, and I'd given an initial statement about the treaty should be interpreted in a purposive fashion, and I referred to Lord Reed's judgment in the Anson case before the luncheon break. And what we say in relation to the treaty...
Sorry, is this the point about whether Section 93 overrides 67, or is this what does it mean by paid to and resident?
No, this is the point, my lady, in relation to the proper interpretation to be placed on the treaty. Because and I think we don't want, it could not be overstated, this is really the core of the respondents' concern in this matter, because the interpretation of the CARICOM double tax treaty is not a matter in which there has been any guidance, judicial guidance at all. And it cannot be overstated that this is one of seminal importance to the Caribbean, because there are about 20 tax appeals before the Tax Appeal Board pending, awaiting the determination of this board's judgment on this matter. How does one interpret the CARICOM double tax treaty of the 6th of July, 1994? And a matter was just adjourned last month on the basis that the decision of your Lordship's relationship is being awaited as to what the treaty means. And we say, very briefly, that the treaty ought to be interpreted in the context of its purpose and object. And the purpose and object of the CARICOM double tax treaty is to be gleaned not only from the declarations which preceded the terms of that treaty, which were referred to this morning, just before the luncheon break, but also by reference to...
That was the declaration in the 1973 treaty.
1973 Treaty of Chaguaramas, which is the agreement on the basis of which the double tax treaty emerged, and which Lord Reed, in adopting the Article 31 of the Vienna Convention, has said you should take into account any agreement in connection with the treaty. And we respectfully suggest that the Treaty of Chaguaramas is such an agreement, which ought to be taken into account. And we've set out in that regard in our submissions, starting at page 2450 in the electronic bundle. Our submissions on the interpretation, taking into account the object and purpose of the treaty as is to be gleaned from the Treaty of Chaguaramas.
I'm sorry, could you just give me the page reference
Yes, please.
again?
2450.
2450, thank you.
Much obliged.
In the current revised treaty referred to there, is there the same provision?
The revised treaty does deal, yes, it's the same provision, yes. That revised treaty is 2001.
Yes.
Yes, but that is after
Post-dates,
the
yes,
after the tax treaty came into effect. And what we say in relation to that is that when one looks at the articles, quite apart from the declaration, it is clear in our respectful submission that the object and purpose of the double tax treaty of 1994 was to encourage interregional trade and investment, and to facilitate the growth of capital within the Caribbean community.
Say that again, encourage intra-regional
Trade and investment, and to facilitate the growth of capital within the Caribbean region, or CARICOM region, or Caribbean community as it's called. To encourage the movement of capital within the Caribbean common market, perhaps not dissimilar to the European community. And it was a regional multilateral treaty. And the question which arises at the core of that argument is that one should not approach the construction of the treaty in a narrow, technical manner. And that is clear from Lord Reed's judgment in Anson and the more recent judgment of Lord Justice Falk in the case of Royal Bank.
Lady Justice Falk, actually.
Yes, I'm sorry, my mistake. Which is in the supplemental bundle. At page 90. And if I can refer to the judgment of Lady Justice Falk in the Court of Appeal, adopting what Lord Reed had said in the Anson case, and the relevant passage would be found at paragraph 27 in that judgment, which would be page 102 of the supplemental bundle. And after paragraph 27, after quoting from Lord Reed's judgment in Anson, what Lady Justice Falk went on to say, he went on to emphasize, and I quote, he went on to emphasize in the same paragraph, the court's predisposition when faced with narrow and technical constructions to favor an interpretation which reflects the ordinary meaning of the words used and the object of the treaty. And what we say to this honorable court is that that should be the guiding reference. Look at the object of the treaty, and that object is to be gleaned from the preamble, from the declarations, and from the various preliminary articles. And when one does that, one can focus on what was intended by the person.
What is it about the result in this case, if we were to hold that this was not artificial, what is it about that result which you say goes against the aim of encouraging intra-regional trade and investment and facilitating the use of capital within Trinidad?
Because there would have been no capital moving within the Caribbean. What would have happened is that monies would have
Isn't there capital moving from Methanex Canada into Trinidad to build the methanol plant?
Yes. What is being generated in Trinidad will be moving straight out of the region to Canada, which is what happened here.
Well, the dividend would, but my lady's point is that there was earlier investment.
Yes, it was investment. Yes.
And the dividends are from taxed profits within Trinidad, aren't they?
No, dividends are not taxed, no.
No, the profits which are taxed before you get to the amount that's distributable as dividend.
Yes. It would be from tax profits. Yes, the profits would have been taxed, yes. But the monies which would have resulted therefrom moving outside of the region.
If this had been, say, a dividend straight to Canada and the 5% had been withheld,
Yes.
what then happens to that 5%? Does it stay in Trinidad or does Trinidad remit it to Canada?
It would stay in Trinidad. To pay, it would be monies accruing to the Board of Revenue Respondent in this case.
So Canada effectively loses out because they have to give, assuming under their tax law, they have to give Methanex, they would have to give Methanex Canada a credit for that on any tax that they would impose on the receipt of the dividend by Methanex Canada.
That may occur, yes, please. What I want to, before my time runs out, if I can just take this honorable court to the construction of Article 4 of the CARICOM Double Tax Treaty. And what we have done is to set out in our submissions at page 2455 the terms of that article. What we say is that, before I get to the terms, what we say is that the Court of Appeal engaged in a narrow and technical construction of the Double Tax Treaty, which was totally inconsistent with the guidance emerging from Broadway's judgment. That's number one. And in relation to whether the Methanex Barbados was entitled to avail itself of the treaty, one has to have regard to Article 4, which is set out at page 2455. It says, for the purposes of this agreement, the term resident of a member state means any person who under the law of that state is liable to tax therein by reason of that person's domicile, residence, place of management, or any other criteria. And we rely on the judgment of the Canadian Supreme Court and the Crown Forest case as establishing how one goes about establishing or proving that you're resident, Methanex Barbados is a resident of a member state. And in our respectful submission, the two approaches from the Crown Forest case, which exist. And what we call on page 2457, the plain language reading of Article 4, you must prove what the effective cause of the taxation is in that territory. You see the quotation at paragraph 116, page 2457. Justice Ikobushi said, under Article 4, it must be shown that the liability to tax operates by reason of one of the listed grounds, and the words being by reason of.
So that's residence, domicile, central management.
Yes. But he goes on to say there must be some sort of causal connection. And what we say in this case is that the effective cause of Methanex Barbados' liability to tax is none of these grounds. The effective cause is its existence as an international business company, IBCA. The International Business Companies legislation in Barbados is a unique piece of legislation in our respectful submission.
But you can only be registered as an IBC if you're resident.
Yes. But
and it was accepted that it was a resident company.
Yes, but the term residence, if I may, I'll go on to explain what the term encompasses in a moment. But if I can just refer very briefly to the fact that the effective cause, we say, is the fact of its being an international business company.
We're told that goes to the rate of tax rather than liability for tax.
Yeah, that's been the argument on the other side.
Correct?
We do not agree with that. He said, because the international business company legislation creates a special regime of taxation for IBCs, if I can call them that, international business companies. And it's clear from the judgment of the Tax Court of Canada in the Alberta Printed Circuits case has been recognized, although obiter, that the IBC legislation is a separate piece of legislation, separate and apart from the Income Tax Act. I think that's crucial as it goes to the heart of our submissions. The IBC Act is a special piece of legislation. It's not a question of rate of tax. IBCs are taken outside of the Income Tax Act. And if
They're taken outside of the Income Tax Act because they're subject to a different regime, like companies are subject to corporation tax rather than income tax. But does that mean that they're not subject to a tax regime in Barbados?
They're subject to the IBC tax regime, not the income tax regime.
But they only need to be liable to tax, don't they?
They're liable to tax under the IBC Act, but not under the income tax
but
Act.
in
Why does
terms
it
of the
matter?
treaty,
In terms of the treaty, what we
is it
say,
enough that they're liable to tax under the IBC regime?
no with respect, for the purpose of the treaty, when you look at the second limb of the Supreme Court of Canada's decision in Crown Forest, it means that you must be subject to the comprehensive tax regime of the country.
So
And
where
it's
is that?
not.
Sorry.
You see, the IBC is not subject to comprehensive tax regime because it's not under the Income Tax Act. It's under the IBC Act. And the IBC Act is a special and separate piece of legislation designed to facilitate international business companies.
Yes, well, if we were to decide in your favour on this point, that would might well have very serious repercussions for the efficacy of that regime that Barbados has set up.
Well, that regime, for some reason, is gone. It was abolished in 2019, no longer exists. But it's been availed of by a number of companies operating in the energy sector. So what we're asking the court to do, however revolutionary it may sound, is to find, first of all, that the IBC regime is a separate and distinct piece of legislation, which is not simply a question of a rate. You pay 1% or 2% or 0.5%. It's a question of a separate levy, taxes charged under a separate piece of legislation, taking it outside of the regime of income tax, not an ordinary corporation. And we say so.
Sorry, so you're reading a lot into the words in the treaty, who under the law of that state, Barbados, is liable to tax. And you say being liable to international business corporation tax is not being liable to tax therein for the purposes of that provision. It has to be,
Yes.
you have to be liable for the full income tax.
The comprehensive tax regime of Barbados, the plenary laws of the country.
Where,
And that comes from the judgment of the Canadian Supreme Court in Crown Forest, paragraph 55, Justice Ikobosi. So if I can refer to that. And it's at page 2465 of the electronic bundle. If I can read very briefly, paragraph.
Where do we have the whole case somewhere?
The whole case is in the
Tab 25.
bundle of the authorities.
All right, as long as we have it.
Yes, you have it. $3176. The full case at page 3176. But the passage we rely on for that submission, full tax liability requirement. We start at page 2464 of our submissions, going over to 2465. what we call the full tax liability principle. And the Canadian Supreme Court, dealing with that, Article 4, which in Canada, U.S. tax treaties, in almost identical words to this, Article 4 that we're considering here.
Was Methanex Barbados liable to tax anywhere else?
Well, as far as we know, it was only liable to tax in Barbados.
Only in Barbados?
And only on income made within Barbados. That's also another crucial point. But before I come to that, I can just expand on the full tax liability point. That's crucial. Full tax liability point are only liable on income arising within Barbados. And that is to be gleaned from sections 2, 4, and 6. If I can, before proceeding to the full tax liability point, if I can just refer to those provisions. In looking at the...
And in Crown Forest, were they dealing with a situation where the entity was liable to tax in more than one jurisdiction, and so there was they had to work out which was the full tax liability jurisdiction?
As far as we're concerned, as far as we know.
No, okay, I've misremembered that.
One jurisdiction, Barbados. If I can just refer to the Act. International Business Companies Act of Barbados. And it's to be found in this Respondent Supplemental Authorities Bundle, starting at page 6. And it's clear from, in our respective submission, from section 2, 1B.
But this, in Crown Forest, as I understand it, Norsk was actually resident in the Bahamas.
Yes. Yes, it was.
And the question was whether such presence it had in the United States qualified as residence for the purposes of the Canadian-US double tax treaty. Well, that's a very different situation from this case. There's no suggestion that the Barbados company was resident anywhere other than in Barbados.
Yes, but we talk, in our respectful submission, we're dealing with the general principles to be extracted from the guidance of the Supreme Court.
Yes, okay.
And what we say, first of all, is that in respect of Methanex Barbados, it was only taxable on monies arising from within Barbados.
But there wasn't another jurisdiction in which it was taxable?
No, as far as we know.
Yeah.
But
And
what about trusts and charities that are set up that are largely exempt from tax or under some special tax regime? Are they then not resident in any particular country for this purpose?
Well, the international business companies legislation was designed to encourage entities to come there and to generate income from within Barbados. And in our respectful submission, that's clear from section 2, subsection 1B, and section 4. With all these sections use the word within Barbados, as well as section 6, 1D. All these provisions deal with entities generating business from within Barbados. So we're saying an IBC was only taxable on income generated from within Barbados. That's one aspect. But coming back to the full tax liability point, what we say is that the Court of Appeal erred in failing to be guided by what residents meant in trying to establish that you satisfy the requirements of Article 4. And if I can quote from the judgment of the Canadian Supreme Court, page 2465, says, the commentaries to the OECD Model Convention, as well as academic sources, indicate that generally the domestic laws of the contracting states employ residents to apply on full tax liability. Under the prevailing practice, a country entering into an income tax treaty extends the benefits of the treaty to a person only that is a resident of the other contracting state. Residence, in turn, is defined in terms of taxing jurisdiction. A person or entity is considered resident in a country if that country asserts an unlimited right to tax his or its income. That's the right based on the taxpayer's personal connection with the country as opposed to the source of income or other assets-related factors. The test of resident requires that the person or entity claiming treaty benefit be fully taxable in the resident's country in the sense of being fully subject to its plenary taxing jurisdiction.
But why do you say it's that Methanex Barbados is not? I mean, Barbados does assert an unlimited right to tax its income and treat it as fully subject to its plenary taxing jurisdiction. It just decides for its own reasons that it's going to impose a lower rate of tax or a more favourable regime. That's not because it can't, if it decides, legislate to tax it fully. It's just for its own economic reasons it decides not to. Is that what they're talking about?
With respect, my lady, what we say is that the full tax subject to plenary taxing jurisdiction requires you to be subject to tax under the Income Tax Act, which it is not. Methanex Barbados is subject to tax under the IBC regime, which under sections 10 and 11 make it very clear in our respectful submission that it's a separate piece of legislation which is not the full plenary laws of Barbados.
So what do you say about the findings made by the tax board at page 270, paragraphs 73 and 74?
Sorry, what's the page?
270. So they say that subject to tax is a full measure of income tax. It's assessed by the tax authorities in Barbados.
I'm so sorry, can you give the page number?
Page 270?
270, sorry.
270.
Thank you.
Yes, and that paragraph, my lady, paragraph
73 and 74.
73 and 74, yes. Well, two things we say. We say the tax appeal board erred.
Sorry?
We say that the tax appeal board erred in coming to that conclusion.
Yeah, but it's finding of fact, isn't it, all this?
Well, finding of fact it was resident.
Right.
Yes, but that finding of fact is based on primarily on a certificate of residency. And what we say in relation to that certificate is that it carries little or no weight. And we say that, and we ask your lordship and your ladyships to come to that conclusion. A certificate of residency, which was placed, great weight was placed on that, but the judgment of the tax court in the McFadden case, which we have put in the bundle, further supplemental bundle.
That's a certificate of residency issued by Barbados.
Issued by Barbados, yes. Carries little or no weight because if one looks at the reasoning in the McFadden case, which is further supplemental bundle, page 17, and we're referring here to how the court treated with a certificate of residency. And that would be at pages 43 and 44 of the further supplemental bundle. And that they were dealing here with the same Crown Forest decision, which we've relied on earlier. And the question arose as to what weight should be attached to a certificate of residency emanating from Japan.
This is the further supplemental bundle at
Starting at page 43. Well, the judgment starts at page 17, but the relevant passage would be at page 43, pages 43 to 44. Look,
Right at the end of the judgment.
at the end of the judgment.
Thank you.
And there was reference to the paragraph 145, concrete evidence submitted but suggests that he's subject to comprehensive liability to the same issue that arises here as imposed by Japan is a certificate of residency issued by the Japanese authorities. And the certificate of residency says so and so. And then at paragraph 147 goes on to say, the appellant says that this evidence is uncontradicted by the respondent. As a result, a prima facie case is established because the documentary evidence says that he's resident of Japan for the purpose of Article 4. Goes on. Where it says, I agree with the respondents that a certificate of residence is weak and in my view should be given very little weight.
That's
Well, we had
because
to
they thought he
read
wrote
on,
it
I think. He seems to have concocted it himself, or got a chum to do it.
Yes, but what I'm saying, quite apart from that, we say that a certificate,
Well, they're
It's
not
not
saying that a real certificate really issued by the Japanese authorities would just be brushed aside, I don't think.
and there was no, it goes on to give the rationale for that. At page paragraph 149, there's no evidence provided that supported the certificate being issued by the judge with the full knowledge of the appellant's particular circumstances during the 3 years in issue. The certificate does not establish the parameters, etc. It's simply a conclusion. It's not known how the official arrived at that conclusion or there's any evidence about the expertise. At paragraph 151, my view, the appellant did not establish that he was subject to a comprehensive tax liability as imposed by Japan for the purpose of Article 4, not been established. We asked this court to come to the same conclusion. The certificate of residency, which has been issued in this case, was issued by an official from the Barbados Revenue Authority. It is BR4. BR4 to the affidavit of BA4, I'm sorry, to the affidavit of Bernard Arundel.
But are you challenging the genuineness of that?
We're challenging what weight should be attached. We're saying that it ought not to be given any weight to certificate of residence.
Why?
Because one does not know the circumstance of the official who signed off on the certificate.
But you've got no, you can't just speculate. You've got no evidence to suggest that it wasn't a genuine authorised certificate.
No, we're not saying it's not genuine. We're saying that
So what do you need to know about the circumstances?
because the circumstances need to go beyond that and to say, well, look here, we know that this company is resident here,
Yeah.
it is incorporated here,
Yeah.
and
Neither of which you challenge.
we're not challenging
No.
that at all.
So what else?
We're
What
saying
else?
that the certificate by itself is not determinative of the issue of residence.
But it's
Very
not by
satisfied.
itself.
By itself.
I thought it was
They paid
accepted.
corporation tax in the relevant
Yes.
tax year 2007.
Yes.
They were recognised as resident for corporation tax purposes.
Yes.
They were recognised as resident for CARICOM double tax treaty purposes. And a certificate was issued. What more do you want?
We want to, quite apart from that, the certificate has been linked in the submissions of the appellant to being expert evidence
Of what?
of the status of having discharged the burden of proving that this particular company, Methanex Barbados, was entitled to the benefits of the treaty.
Well, I think, as I understand it, you accept that it was liable to tax under the special regime,
Special regime, yes.
for which purposes it had to be resident in Barbados.
Yes, because
So I mean, as I understand it, the argument you're putting forward in this respect actually focuses on the limited nature of the tax regime applicable to the Barbadian company as an international business corporation. I didn't really understand you to be challenging that it was a genuine international business corporation.
No, we're not challenging.
No, so really the certificate is neither here nor there. My understanding is it's common ground. It is a genuine international business corporation.
Yes, we're not challenging.
Your argument is, well, as a matter of the proper construction of the double taxation treaty, that doesn't work. It's not enough because they're not subject to the full
Yes.
income tax regime.
Much about, yes, that's,
Then
yes.
I understand it, yes.
No,
Mr. Denver, you're almost out of time.
yes. Yes.
Wind up your remarks. I do wonder whether you're minded to say anything about Section 93 and Section 67. We haven't heard it.
We've already, if I can just refer you to the passages where we deal with that. Yes. That would be at page, starting at pages 2443 to 2444. In essence, what we're saying is that Section 67 is not being overridden by Section 93. And
Sorry, I didn't hear that.
Section 67 has not been overridden.
Section 67
Has not been overridden.
has not been
Has
overridden.
not been overridden. And we say so at page 2444. And that there's no inconsistency between Section 67 and any provision in the CARICOM double tax treaty. So that Section 67 enjoys its continuing existence, and that the Court of Appeal and the Tax Appeal Board were correct in relying on it and applying it to the facts of this case. And I think we said so in our conclusions at page 2468, paragraph 153, letter D. Page 2468, Direct Honorable 2468, paragraph 153 at letter D. We've put that in the summary of conclusions.
Yes. So you're simply referring us to your written submissions?
Yes, please. And therefore, if I could just end by saying that in terms of the full tax liability principle, that this particular case does not qualify as satisfying that requirement, because Methanex Barbados was not subject to the full plenary laws of Barbados under the Income Tax Act. Special limited regime. It had nothing to do with paying 5% or 2% tax. It had to do with what were the plenary laws of Barbados, what was a comprehensive tax regime in Barbados. That was embodied in the Income Tax Act, and Methanex Barbados was not within that category. Those would be my submissions.
Thank you.
Obliged.
Thank you very much.
Thank you.
Denver. Thank you.
Very brief reply, my lords and my ladies, if I may be permitted. I want to just briefly respond to the submissions that were made on the bank account and where the cash went. There is no real controversy as to how the cash ended up in the bank account in Vancouver, and there's no controversy that those bank accounts were the bank accounts of Barbados and Cayman, and there's no controversy, or there should not be after the passages that were reviewed, was that those bank accounts were being managed as part of the Treasury function. There's been a lot of focus on cash, and of course, our tax system doesn't turn on where the cash ends up. These tax systems turn on where the income ends up. We tax income, not cash. And for that purpose, I just want to give my lords and my ladies a reference, which is page 1828 of the electronic book, where you will see a tax return filed by Methanex Barbados in that jurisdiction in compliance of its obligations as a resident of. So we actually report the income in Barbados. The focus has been the cash, but the focus ought to be the income, and the income is being reported in Barbados.
The Barbados tax return.
Yes, at page 1828. Just a couple of other observations.
I've just got that open here, and the income that is there reported is what? Could we see?
Income that came from.
If you could just show me where it is on the 1829.
In Barbados dollars.
Oh, it says. So the point is. I see.
What does it mean, gross net, given that it's not a trading company, though?
Well, it's not a. My lady Rose asked, what is Barbados's business?
Yeah.
And Barbados is a holding company, and the tribunal, when the tribunal talked about what function does Barbados serve, the submission was, and it was accepted, that Barbados is a holding company. Trinidad is an unlimited liability corporation, and therefore Barbados was holding the equity interests in two Trinidad companies and was acting to limit the risk because the bottom company was an unlimited liability corporation. So it was nothing, there was nothing more to it than a holding company. But it was a properly constituted holding company, as was the case in the Holden case.
And it can be an international business company and just a holding company?
Yes, yes.
So the 169,977,183 there is the gross trade or business income. Is that then just the dividends coming up from?
With your permission, may I ask Mr. Walker to address that question?
Right.
Just.
Go on, Mr. Walker.
Yes, my lady. My lady, if it helps, at page 1766, where Mr. Skinner explains the income that has been received by the company and included in the tax returns. It does get a little bit confusing because with the tax returns, you must convert it into Barbadian dollars.
All right. Well, never mind.
And there were also tax losses in the previous year, which then explains some of the other adjustments.
I see. So that 16179 figure is in brackets, is it? As a loss. Oh, well, there we are.
I just have two more brief comments. With respect to the old treaty and the new treaty and what happened in the Court of Appeal and what use was made of that treaty, I don't really want to get into who said what at the Court of Appeal. There's really no dispute on the key facts. Key fact number one, the 1973 treaty was a treaty that was entered into by the parties on that treaty. That's not disputed. Fact number two, all the signatories of the new treaty in 1994 were also signatories of the old treaty, the 1973 treaty. That's not disputed. Can't, because it's on the face of both treaties. And the only point I was making when I went to that treaty was to say the signatories of the new treaty were part of the old treaty, which had Article 22 there. And then they moved to the new treaty, and Article 22 doesn't exist, meaning the new treaty replaced the old treaty, and Article 22 doesn't exist with essentially all the same parties, and the only inference that can be drawn is that the very things the respondent is asking for, which is the limitations be read in, would be contrary to the...
Well, what's set against you is that one has to read that in because the 1994 treaty is made pursuant to Article 41.2 of the overall Cheragamus Treaty, and that effectively, I think it's said, has the same effect as Article 22 of the old 1973 Double Taxation Treaty.
Well, my lady, I would respectfully submit that, in fact, it would be exactly the opposite, in the sense that when the new treaty partners when the partners came together to sign the new treaty, and if they had intended the new treaty to be what I have, colloquially described as a closed treaty, then they would not have rejected Article 22. They would, in fact, have done the opposite. So the point is the absence of 22, in fact, demonstrates that my friend's point is, and I say this with great respect, exactly incorrect. One final observation, and I'm going to do this, Crown Forest is very confusing in terms of the facts of the case and the way that it's written up. But the analogy that I use to describe Crown Forest is this. I've used this analogy before. Crown Forest was a case where Norsk, a resident of the Bahamas, was earning something called effectively connected income. So it had a source of income in the United States, and it argued that it was a resident of the United States for treaty purposes because it had this source of income. An analogy would be, and the analogy, trying to make it as close to the UK as possible, is if somebody in the UK owns a rental property in Spain and they're earning some rental income in Spain, and they showed up and argued, I am a resident of Spain because I'm getting some rental income from my condominium in Spain. That's the analogy to Crown Forest, and the Supreme Court of Canada rejected that and said, you have a source of income in the United States called effectively connected income, but you're not a resident here because the United States doesn't assert a plenary power of taxation over you. You merely have a source. That's exactly what Crown Forest is, and that's why it's nothing like the case before you. The most interesting part of Crown Forest is when Crown Forest was argued in the Supreme Court of Canada, the Canadian government brought the U.S. government as an intervener to the Canadian Supreme Court, and the United States government made submissions to the Canadian Supreme Court saying, these folks are not our residents. We assert that don't let them tell you they're our residents. And that is why the certificate has some influence in that in this court, Barbados is saying Methanex is our resident, and quite different from what the United States was saying in Crown Forest. Subject to any questions, those are all my submissions. Oh, yes. My Lord Richards asked a question about whether there were dividends in other years. I think you asked, and there is in the record at page 1764, paragraph 19 lists other years in which there were dividends paid.
But is there anything that shows that they go through the same Vancouver bank account controlled by the same Treasury function officials?
No, there's nothing on the record that says that. Subject to any questions, those are all my submissions.
That's right. I don't know if there's anything you want to say about the point on Section 67 and Section 93. We haven't heard from you on that.
Yeah, I was, in the interests of time, I decided not to speak to that in my submissions in chief, and we are completely content with everything we've said in our written submissions. We rely entirely, anything I would say now would just be repeating what I said in the principal submission, particularly in light of what the respondent has said. I don't think there's anything to reply on that point.
Thank you.
Thank you, my lords and my
I don't
ladies.
think there's anything else. Thank you very much. Well, Mr. McGee and Mr. Denbo, we're very grateful to you for your submissions. We're also very grateful to those sitting alongside you and behind you for the preparation of that, and clearly a great deal of work has gone into that. We will take time to consider our decision, which we will deliver in due course. Thank you all very much.